Yes, a very good afternoon to all participants from India, and good morning to our guest, Professor Dr. Graham Dutfield. Anand College of Legal Studies has been organizing webinars with distinguished legal luminaries. And today's speaker, Professor Dr. Graham Dutfield, is a distinguished legal expert in the intellectual property field. And today he will be speaking on the topic of pharmaceutical business strategy and the expansion of protectable intellectual property subject matter. Uh, Good for innovation, good for the public. But before handling the session to Dr. Dutfield, I would like to invite Dr. Rekha Kumari Singh, in charge Dean, Faculty of Law, Sardar Patel University, and in charge Principal, Anand College of Legal Studies, for welcoming and introducing today's expert. Over to you, ma'am.
Thank you so much, Mr. Gururaj. It is indeed an honor for me to introduce and welcome our today's guest and speaker for today's session, Dr. Graham Dutfield. Sir has sir is serving as a professor of international governance at the School of Law, University of Leeds. And prior to joining the University of Leeds, he was the Curtis Smith Senior Research Fellow at CCLS Queen Mary. From 2001 to 2002, he served as an academic director of ICTCAT UNICEF TAD capacity building project on in IPR and development based in Geneva and was submitted paper titled Project Protecting Traditional Knowledge and Folkware, a review of progress in diplomacy and policy formulation. He is an adjunct professor, Center for Studies of IPR, Zhengzhou University of Economics and Law in China, and research affiliate in the IPR and Technology Program, Osgood Hall Law School, York University, Toronto. Sir presents his research paper around the world and has given lectures at various prestigious institutions, including University of Oxford. Apart from that, Sir has also served in that is the Law School Canada and NALSAR and the World Bank. He was also invited as a guest lecturer at the Center Intellectual Property and International Trade Court of Thailand before the Chief Justice and over 50 judges. He has also advised governments, including those of Brazil, Ghana, Namibia, Saint Zambia, as well as the Portfolio Committee on Trade and Industry of South African Parliament and the former United Nations Special Rapporteur on the right to food. However, he has been often been referred as one of the world's leading experts on the issue of traditional knowledge and intellectual property, a leading thinker on the IPR in the life science industries. Presently, Sir is a member of Traditional Knowledge Expert Group convened by the Center for International Governance Innovation, a leading Canadian think tank, and also partner on the Voice for Higher Justice project led by the University of Cape Town. It is really honor for us that Sir has accepted the invitation, and we are really honored and proud to have you, sir. And we once again we welcome you on behalf of our organization, Anand College of Legal Studies, and are looking forward for your expertise knowledge, which will be benefited to our student and which is going to helpful to in their future endeavor. So once again, sir, we welcome you and looking forward for more future association as well.
Okay, thank you very much, Dr. Singh, for that very generous introduction, and to Dr. Devarhubli for inviting me. So what I'm going to do is talk about the pharmaceutical industry, the industry itself, its way of doing business. Particularly the research-based industry, its way of doing business is very much IP based, but also it's an industry which is heavily regulated as well. So regulation and intellectual property kind of operates as part of a wider system. And the question to be asked, I think, is that we provide these exclusive rights to industry because we say it creates incentives. It allows them to control markets and make money, which will then be used to do more research and development. And the question is whether we are creating the right kind of incentive structure or whether there are problems. And I'm going to argue, as I have through a book that I just wrote that's just been published, which is a history of the pharmaceutical industry. What I'm going to say is that the way that the industry operates is something that we ourselves, the citizens, have to bear some responsibility for in a democracy. And if we are not creating the right incentive structure, then we need to change it. All right, so what I want to do is to share the screen and show you my slides. Last time I did on Teams, it didn't work very well. So if there are any problems, well, I've already forwarded the slides. So if it doesn't work, it's not a big problem. I'm going to go to slideshow now. And if you can't see this, then please do let me know. So is that visible?
Yes, sir. Yes, sir. It's visible.
Okay. If I change it, is that visible too? I've just changed the slide. Does that work?
No, sir. It's on the first slide itself.
Okay. Then all right. Then I'll do it this way. Okay. I think this way it will work. Okay, without doing the slideshow. All right. Okay. All right. So let me introduce the industry by talking about some very basic concepts. Well, these are basic. When I say basic, it doesn't mean simple. I mean fundamental. And the first question to be asked is, what is a pharmaceutical? What actually are we talking about here? We can say it's a medical product, but it's not quite that simple. So a pharmaceutical, I would say, is a manufacture. It is something that is manufactured. It comprises a defined chemical agent. It is a chemical, essentially, and it is administered. It is administered to humans for an intended health response. When I say intended, that doesn't mean it necessarily works, but it is intended, and it is not a food or a cosmetic. Now, that's quite important because historically, and you will know in India that the idea that you have medicines here and foods there, that distinction is one that for most of human history did not exist. So foods and medicines, they were very much an overlapping categories. In the modern pharmaceutical industry, it's completely different, right? You don't eat an aspirin because you're hungry, right? You eat it for a particular medical purpose. And that's very important, as I think will become evident. So basically, a pharmaceutical is a chemical that reacts with the human body to cause a therapeutic effect. I won't go into the science here. But what about types of product? There are at least 5 different types of pharmaceutical product. There are chemicals made in the lab, in the factory. That's most types of modern medicines. There are extracted chemicals made by life forms, hormones, penicillin, antibiotics are primarily purified chemicals that are taken from nature. And then there are so-called biologic drugs, things like monoclonal antibodies. These are highly complex products, very, very hard to make and very expensive to make. And then we have vaccines and cell therapies. So if you look at these images, the question is, are these pharmaceuticals? One is radium. Those of you who know the history will know that Marie Curie, the great Polish scientist, was associated with radium. It's perhaps less well known that her bones are radioactive, and she died of cancer caused by her research. So she gave her life to her research. So radium is very much a dangerous product. It's certainly not available now as a health product. It's extremely dangerous. It will cause you cancer. But at one time, it was actually marketed. It was actually marketed as a pharmaceutical. So therefore, the question is it a pharmaceutical or not? Well, in those days it was. The fact that it's dangerous and probably just doesn't work doesn't take away from the fact that it is was a pharmaceutical product. In the images in the middle and on the right, this is quinine. As you know, quinine is used to treat malaria. So sulfate of quinine is a pharmaceutical product. Quinine, as an extract of the bark of a tree, is not really a pharmaceutical product as such, according to my definition. So it has to be actually manufactured, and that's the important thing to make it a pharmaceutical product. If you go to this picture here on the left, this is a guy called Carl Link. He was the discoverer of a product which became known as warfarin. Warfarin is a medicine that is still used for people who have severe cardiovascular health problems. It was originally a rat poison. Now, can you believe that a medical product was originally a rat poison? Is it a pharmaceutical? Yes, it is. It kills rats. It can kill humans if you take too much. The top, this is a bit of a joke, really, but this is coffee sold as if it is a pharmaceutical product, and of course it's not, even though coffee was originally promoted as a health drink, but of course not now. So it is not a pharmaceutical, even though it may have some health benefits because it is a food or drink. Therefore it is excluded, because it is not just what is a pharmaceutical, is a matter of regulation. Right, it is defined not by the dictionary as such, but by regulation. So according to regulation, it is not a pharmaceutical product, even if we may actually find it, it does give us a lift when we drink. If we're tired, it picks us up. So it does have certainly, you know, a human body response, which may be positive. Okay, penicillin. Well, penicillin as a modern medicine is a pharmaceutical, but as a mold, a naturally occurring mold, it is not a pharmaceutical. So this raises an interesting thing. Not only is it not a food, but pharmaceutical in the modern sense is actually a poison. If your body actually sort of responds in a physiological or therapeutic way, then how do you distinguish this from something that does you harm? Well, it's largely a matter of the dose, of getting the right amount, because almost everything, virtually everything is toxic, possibly except water. Everything else at the wrong dose is toxic. And that's why you have to have a system of regulation before a medicine can be approved for sale. And regulation includes products, safety, does it work? Also manufacturing quality standards, classifying diseases, and access. And arguably, intellectual property rights are another form of regulation, and these include patents, trademarks, protecting names, logos, slogans, shapes and colors, and also data exclusivity. Those who know about the TRIPS agreement will know it's in TRIPS, Article 39 TRIPS, data exclusivity. Now, note the first one here at the top on products. Naming and marketing rights are also important, and that means that intellectual property does intersect quite closely with regulation. And that also implies that if you want to have a better pharmaceutical industry, if you want industry to get into areas of health where we want them to do research and to invest in, then we need to look at IP as well as regulation. Where we want them to do research and to invest in, then we need to look at IP as well as okay, so regulation then has market shaping outcomes. It does shape the market. It creates barriers to entry. It offers opportunities for experienced users to sort of game the system, to cheat a little bit, and that's what we're gonna have a look at. Now, before we go further, I'll show you this image here, which is actually a medical product which is called thalidomide. Now, thalidomide is has a terrible reputation in the UK and in many European countries, and the reason why is that thalidomide is extremely dangerous for pregnant women because it used to be prescribed to pregnant women. And it turned out that quite a lot of women who took this medicine gave birth to babies who had terrible deformities. They were born without arms and legs, so absolutely horrific deformities. And so clearly for pregnant women, thalidomide is extremely toxic and actually dangerous. So you might think, well, surely this should just be completely banned. It should be totally illegal for thalidomide to be on the market. In fact, that's not quite the case because it does have medical uses still. So this is a very toxic product, highly dangerous if the wrong people take it. But as you will see, there's a warning here that it produces severe life-threatening human birth defects if taken during pregnancy. And yet it is still on the market. It's just that pregnant women cannot take this. So it does have other health benefits. So you can see how important regulation really is. You can also see how dangerous medicines can be. And that's why, of course, we have to have these safety and effectiveness testing to take place. Okay, so from the perspective of industry, their business is to make chemicals that are selectively biologically active, and they are regulated as if they are potential poisons. In fact, historically, poisons can become drugs, and of course, thalidomide itself is a terrible poison, but nonetheless, it can, on balance, actually be of benefit to some people. Okay, the other considerations for industry are much more related to business. Is it best to cure people of a disease, or is it best to relieve the suffering from the disease, but to keep people alive? Is it better to keep people alive or to cure them? Because the cynical view is that if you cure people, then you run out of customers. Whereas if you keep people alive, they can potentially take medicines for many, many years. So for example, I mean, I have high blood pressure, so I take medicines, and if I mean, I may need to take these for many, many more years. That's good business. I keep on taking these medicines. Is it better to be life-saving or life-enhancing? Again, it's a similar question. Is money to be made in meeting desires or meeting needs? We could have cosmetic drugs, as we do have, and these attract investment, but they do not actually save lives. They meet desires. They don't really meet human needs. And what about the poor? Those who can't afford, or they live in countries where health budgets are low. What about these people? Are we creating the right incentives for medicines that disproportionately affect poorer people? Okay, so I'll move on. So how does the industry make its money? What are its motivations? Well, the motivation primarily is to maximize shareholder value by making as much money from sales as possible, employing all means possible. So obviously there's research and development spending, marketing and pricing strategy to generate profits and maximize them, and to expand use of approved medicines by seeking to add new indications. And that's really, really important. So you find, let's say a medicine that treats a certain type of cancer. And then once that is approved, then these companies will try and see if that medicine works for other kinds of cancer as well. So they're expanding the patient base by adding new medical problems for which this drug is a solution. that expansion. So that happens often after the marketing approval of the drug. So they want to have as many people as possible to use this medicine. But there are obviously challenges. This is quite hard to do. You need to satisfy shareholder investors by providing income streams. The market exclusivities are always temporary. They don't go on forever. It's also perhaps true that it gets harder and harder to discover new things and develop them because lots of the easy stuff has already been done. And it's also expensive. It's risky. There are massive failure rates. They often fail, these medicines. They look promising, and after testing, it turns out they don't work very well. Another really important thing is that patients respond in different ways. So you might have exceptional responders, those people who benefit very, very well, or they respond very, very well to a drug. On the other hand, others may find the drug not beneficial at all. It may even be harmful. Okay, and then you have unharmonized regulations and IP laws in overseas markets. Okay, and large corporations tend to be more conservative than smaller ones. They're slower to change, whereas the small companies may be more creative, more innovative, but they often lack the money to get their product to market. So the companies with the money can be very, very conservative. The small companies who are much more interesting, radical in what they're trying to do, just don't really have the money. Well, licensing is a way to actually connect the big and small companies positively, but can we do better? That's an important question. And there's also a massive lack of transparency, something I've heard from a Professor Chas Bontra at Oxford University. He says there's lack of transparency, makes it hard for companies to learn from other companies' failures. There's massive duplication, companies doing the same things because they don't know that the things they try haven't already been proven to have failed by the companies. That you don't publish, you don't report your failures, you only want to talk about your successes. So there's a lot of duplication, a lot of money is wasted. So in terms of how industry responses, well, in good ways perhaps, but also in bad ways. I'm just going to focus on the bad ways, not because I want to be biased, but because actually I think I'm trying to look into ways we can make things better, rather than to say it's all fine and business as usual is acceptable, because it's not. So there's a tendency to focus on what we might call variations on the theme, and it rather unambitious incremental innovations. Treatments for reducing risk of future ill health. Risk factors such as high cholesterol or high blood pressure, non-communicable chronic and other non-lethal conditions require continuous consumption. So the ones that drugs can certainly help you, but they're not going to cure you as such. And these are for illnesses that probably won't actually kill you, right? Well, of course, this research is still really important. But in investing in these things, are we perhaps missing out on other things that really matter? And there's a tendency not to focus on cures, which would entail only a temporary consumption. And of course, the medicines that maximize revenues in rich country markets without regard to ability to pay in poorer countries. And of course, other things as well, which I don't have time to get into, but I will focus on so-called life cycle management practices, using IP and regulatory exclusivities to extend effective monopolies. And this is where patents come in a big way. Patents come in a way, so-called evergreening, which you may have heard about, extending effective monopolies, and I'll see shortly how that happens. And then shifting patients onto new products that provide marginal therapeutic advantages, or maybe none at all, while taking the old medicine out of production. This is sometimes referred to as line extensions or product hopping. So in a sense, so I'll give you an example later of how a company will market a follow-on product with a different name, which is no better than the earlier one. But they'll be able to charge a higher price because it is under patent and it's more expensive, so more revenues. But it's rather a kind of cynical game that's being played. Okay, well, I've sort of talked about this already, but this is something, if you have the slides, you can have a look at this later. So I won't need to talk about it now. So what can these firms now patent? Well, of course, I've put in bold type the new areas, the relatively new areas. Of course, it's been quite common for patents on new medicines, on new products, and new processes. So these are mostly not that old. Of course, in India, in 2005, I think was the year when the first one came in. Processes, yes, they were patentable in India for quite a long time. Numerous other countries only allowed new products to be patentable in quite recent years. What about further uses and new methods relating to other things? Well, in Europe and United States, it's for quite a long time, it's been possible to have a patent on a new indication. So in other words, aspirin is an old product, so you can't have a patent on aspirin as a treatment for headaches and fevers because, of course, it's very, very old. But if you've discovered that aspirin can treat some other disease, let's say maybe aspirin could be used, I don't think it's true, but it could be used to reduce the symptoms of COVID-19, well, then you could have a patent on aspirin for that particular indication. Is that a good thing or not? That's a question that is much debated. But also, it's possible to have patents, at least in Europe, on new dosage regimes. So if it's not obvious that 5 milligrams a day is more effective than 10 milligrams a day, then maybe you could get a patent on the use of this medicine, this old medicine, at a dosage of 5 milligrams a day rather than 10. You could possibly get a patent actually on that. You may think that isn't that a bit crazy, and I think it is a bit crazy, but there we are. It's also possible to get a patent where you are able to use a cytogenetic test to identify certain subpopulations or certain people who benefit more from an existing medicine than other people. That's something I've written about before, and I love to talk about it, but I don't think I really have the time. Also, incremental, very slight modifications, slight tweaks, new forms of old chemicals. So-called enantiomers. I'm not a chemist, but I will just say that there are sometimes you have a molecule that comes in two forms, which are a mirror image of the other. And a lot of medicines are a half and half mix of both versions of this chemical. But sometimes one version of the chemical has a better therapeutic effect than the other, and then you can get a patent. Even though it's already disclosed really in the first patent, you can maybe be able to claim novelty in the fact that you create one version of this already existing chemical because it has some kind of health benefit that the other version doesn't have. Okay, so let me sort of move on. What I'd like to do briefly is to talk about economics in relation to technology, a very old paper, 1987 from the United States, where they drew a distinction between complex technologies and the discrete technologies. Now, a complex technology is a technology is a product that contains many complex parts that are interacting together. And these economists figured out that in certain areas of technology, like electrical or mechanical fields, engineering, a lot of the technologies that are new are likely to be complex. And this means that it's very hard for a single patent to provide effective protection of their invention. Whereas with chemicals are sort of discrete technologies because it's one thing and that's the thing. So, for example, I mentioned aspirin before. Aspirin is a chemical called acetylsalicylic acid, ASA. So that is a discrete technology. It's a small molecule that can be described, named, and defined. Therefore, a patent on that chemical will give you quite effective protection. And this is quite important when it comes to talking about patents and medicines. So let me first explain a little more about how you sort of distinguish between complex and discrete technologies. So aspirin is a discrete technology. It is ASA. It's a single chemical, essentially, that is the effective part of this medicine. On the left, you have a mobile phone, which is very complex. It's complex in the sense that it contains many parts, and there are separate IP rights on all of those parts. There are patents, there are designs, trade secrets, copyright, trademarks, and not just on one thing. So it's very hard for one patent to capture the whole technology. Now, when it comes to medicines, things have changed. Things have changed, one, because some modern medicines are now complex technologies. And the other thing is that because patents now, I'll go back to that earlier slide, because patents protect so many different things, it now becomes possible for one drug to be protected by a large number of patents, as if it is a complex technology rather than a discrete one. So by law, you are turning discrete technologies into complex ones. I'll give you examples here. So one is, I'm going to show you here, Humira. Humira is a monoclonal antibody drug. It is a biologic. It is a massively complicated drug. It is so complex that it has to be. You can't make it. It can't be manufactured by humans. It can only be manufactured in living animal cells. In fact, they use hamster ovary cells which are engineered in order to make this kind of, which is a so-called monoclonal antibody. It's incredibly complex. So yes, this is a modern medicine that is a complex technology. In that sense, it's more like a mobile phone than it is like aspirin. And look what's happening in the United States. How many patents applied for on this one product? Over 250 applications, 130 granted patents. The monopoly is not the usual 20 years. It is 39 years now. And maybe the company is going to find more things to patent. And that monopoly could become longer than 39 years. Of course, almost all this patenting has taken place after the approval on the drug was done. So now you have all these patents. So it's a bit like a mobile phone, right? You have lots and lots of patents. But even small molecule drugs, so Lyrica is a drug that's a bit like aspirin. It is a so-called small molecule. So why isn't there just one patent on Lyrica? Well, the way that so many things in medicine are now patentable means that even with a discrete technology, it becomes legally a complex one thanks to patent law. 118 patent applications, 68 patents issued, 39 years of monopoly. I ask you the question, is this right? Is this good? Is this how it should be? And it's not just about patents, because what's often overlooked by many scholars is that trademarks are also incredibly important in this industry too, particularly in view of the fact that trademarks have expanded in what can also be protected. So just as patents have now had this expansion into other areas, you're getting the same also with trademarks into the visual appearance of the medicine itself. And I'll also give you examples here. Trademarks are also very, very important in terms of market power. And of course, trademarks, unlike patents, are indefinite. I mean, look at this trademark here, the very famous Bayer, which they actually have 100 years ago. Aspirin came actually 122 years ago. In 1899, aspirin came on the market and was patented in some countries. And the company was pretty clever, and what they did was that they put the so-called Bayer cross, on the actual pill itself. So when you take the pill, you see the Bayer. So the association between Bayer and the aspirin product is actually stamped on the actual pill itself. So this is a very old ad. On the right, that's actually Frankfurt Airport, and of course the Bayer logo is still in force. It's still being used. It's still a very valuable trademark over 120 years. And new things are protected. So this is actually extract from my book, and on the top left is Viagra, and the company has which is Pfizer, has a trademark on the color and the shape of the pill, that diamond shape. It's the blue pill, and so they have a trademarks on the shape and color of the pill. They also in Europe have a design right also on the shape. So and this means that Pfizer, as they recently did, they managed to get an injunction to prevent an Indian firm, Dr. Reddy's lab, from importing generic Viagra using the blue color and shape into the United States. Interestingly, down below, that is Revatio. Revatio and Pfizer are chemically exactly the same, but they look completely different because they are for a different health problem. So sometimes the same chemical can be separately branded for a different market. Losec, well, Losec or Prodosec in the United States, which is omeprazole, is you see they made it purple, and they use a lot of purple on the packaging, and because customers kept asking for the purple pill, AstraZeneca managed to get a trademark covering the purple pill because it had acquired distinctiveness for use. So they got a trademark on the colouring of the pill and on the phrase "the purple pill." Now this is omeprazole. It's the generic name. Now what AstraZeneca found out was that, now I mentioned to you before about enantiomers. I see the time's passing quite fast. I'll finish in 5 minutes, okay? Enantiomers. So what did the company do here was that it discovered that one version of the same molecule. So it's the same molecule, the same atoms, the same proportion of atoms, but in a different shape. They found that one version of the molecule provided the therapeutic effect. The other version provided no positive or negative effect. It was completely irrelevant. So they separated out, and they got a patent on the molecule, either the left or right-handed molecule, version of the molecule, and got a separate patent on that, and they marketed under a different name, Nexium. They retained the purpleness, but onto a product with a completely different name, not Losec, but Nexium. And in so, and then they took their own Losec out of production, and they shifted patients onto the new purple pill. But the new purple pill, Nexium, is chemically identical to the Losec, with the only difference is that instead you prescribe Nexium at half the dose. Half the dose, because half of the molecules of Losec don't have any therapeutic effect. So you take one version of the molecule and put that into a pill, and the only difference between the two products, the only difference is you just take the half amount. Otherwise, exactly the same in terms of the patient experience. But they've marketed it as if it is a completely different thing. Now, in fact, there's been a fair amount of jurisprudence here, litigation, including in India. There's a case in India 2002 where the court in Delhi held that generic producers, just lost it again, that generic producers could sell their own branded sildenafil, which is Viagra, but not using the blue color. And our George Scaria and with his colleagues have actually published a good article about this, about the India's cases. I mentioned already about DRL and their esomeprazole, their Nexium, and but of course, in a sense, by allowing companies to use trademarks for color and visual appearance of the pill after the patents have expired, is that really good for the public? And I would say probably not, because actually, generic firms should be allowed to use the same visual appearance, because in doing so, that is good for the public, and it is less confusing to patients, because chemically it's the same. So why shouldn't it look the same? It's interesting to note that France recently passed a law which says that you can't enforce trademarks when you have a generic drug, that the trademarks on the visual appearance or texture of the product is not enforceable in this case. So in France, AstraZeneca would not have been able to sue DRL for trademark infringement. And that's probably, I think, good policy. So I kind of agree with France on this. Okay, so problems with modern medicines. There are many problems with modern medicines. Not all of them work. Sometimes they're actually not even particularly effective. Statins, for example, don't benefit. Apparently, most people who take them. And recent research has suggested that lots of the modern drugs are not necessarily much better than existing products. That's evidence from Germany and from the United States. They're expensive. They're not necessarily providing really good health benefits. I don't want to be too negative. Right? Lots of modern medicines are incredibly good and very effective, and we do need to have them. But sometimes their effectiveness is rather overrated by the industry. And this article I found, I think, in Nature Biotechnology recently. As you can see, these studies again show that incremental benefits of new drugs are often a bit disappointing. And in fact, of course, you can have drugs for fatal adverse drug reactions. Why is it then that modern medicines are not always effective, and sometimes they can actually be harmful? Well, they're harmful because they are poisons, obviously, right? Which I've shown you earlier. Well, I don't want to be too hard on the industry because humans do vary at the the molecular level. Lifestyle, environment, any combination of these factors can affect how humans respond to a medicine, from very positive to extremely negative or harmful. And it's not necessarily about quality per se. It may also be that we need to have more sort of personalized medicine. We need to know more about the individual person, about individual difference, because that can really affect how humans respond to a medicine. But it's also possible that we are creating or condoning perverse incentives. And that's what I think is going on. So here's my last slide. If we want a better alignment between private incentives and public benefit, we should never be satisfied with what we've got. We should always want better. We need to be ambitious. And if the industry isn't providing the right, if we're not giving industry the right incentives, that is a regulatory issue. We need to look at not just intellectual property, but we need to look at the whole system as a whole and see how we can actually change it for the better. So I'll just finish by saying that to make the industry work better, we must take an ecosystems approach and not just a reductionist one focusing on a single factor to exclusion of the others. A better balance between business interests and social optimization worldwide, and not just looking at individual countries. We need to look at it a big picture, and we need to be global in how we analyze and critique and try to design policies that make health outcomes better for all of humankind. Thank you for listening.
Thank you, sir. Thank you for the informative session. Now the floor is open for question and answers. If any participant has any query or any clarification or any question from sir, just you can unmute your mic and you can ask or you can just put your question in the chat box.
Okay, I see a question.
May I ask, sir?
Yes, please do. Yes. Yeah.
Very good evening, sir, from India.
Thank you.
So my question is in two folds. One
Yes.
is anything on the international non-proprietary names on how the world at large can come together on the international non-proprietary names, because under the Indian law, under section 13 subsection 2, if there is any molecule pertaining to INN, then that particular trademark should be not registrable. So therefore there should be a mechanism throughout the world where such things can come. That is the first part of it.
Yeah, okay.
And the second question is, if a particular trademark says it's a banned product, maybe that molecule due to government policies gets banned, and how can I reuse the same brand, because it may have got a tremendous market, such as aspirin. Maybe by tomorrow some government says that aspirin cannot be used anymore further. Can I use the same trademark of aspirin in a different segment or in a different therapeutic? That would be my two questions.
Thank you very much for the questions. Okay, let me try my best to give you a good answer to both. Okay, so the first question concerned international non-proprietary names, and for those who don't know too much about this, there is the World Health Organization has oversees a system of international non-proprietary names. These are names that cannot be trademarked. They are generic, and these names usually consist of, let's say, simplified versions of the nomenclature that chemists use to name chemicals. So obviously, so for example, in the UK we have a product which we sometimes call Panadol, but the INN is paracetamol. which you probably have. In America, they call it acetaminophen, but it's the same thing. So there's more than one, sometimes INN. So these are sort of generic names. So nobody is allowed to actually own these. But of course, a slightly awkward question or awkward issue is that the big pharma, the big industry will say that the non-proprietary name is the name for just the active ingredient, right? Whereas the brand name is for the product. And ingredients and products are not exactly the same thing, right? So obviously, if you aspirin, it consists of an active ingredient, but it's not the only thing in that pill. There are so-called excipients, which are the non-active parts of the medicine, and those non-active parts are meant to, for example, basically your pill, you swallow a pill, it goes on a journey through your body, right? And those other chemicals in the pill help that pill active ingredient to go on that journey through the human body, so it reaches the parts where the therapeutic event is supposed to happen. And sometimes those so-called excipients can have some kind of positive, well, they're meant to be positive, yes, but also their effects can be such as that one may question whether a generic drug sold under the INN name is exactly the same in its effect on people as the branded product. Now, industry itself, big pharma would like to say yes, it's different, right? For small molecules, I think that difference is likely to be very minor, very unimportant. But for more complex drugs, it could actually be important. Right? So although I'm generally quite critical of the industry, I think sometimes we have to be honest about safety. I think it's really important. So are they interchangeable? Well, the industry has an incentive in saying they're not. They're not necessarily the same in their effect. And one must be skeptical because they have money behind the statement. But it doesn't mean they're lying either necessarily. One has to be objective. So that's not a particularly clear answer. But to say it sometimes is very simple, but sometimes it's complicated, and we have to know that difference. So interchangeability is really important because most of the time it's okay and it saves money, and the IN system does really help that. But there may be sometimes where people may actually respond differently. There's also placebo effect, a psychological effect. Some people think that a branded product works better than generic. And if they think that, it may be that is reflected in how they respond differently to what is essentially the same thing. About trademarks, well, of course, one of the most famous old trademarks is heroin, which of course is a very tainted brand now. Now, heroin, the generic name is diamorphine or diacetylmorphine, and I know for a fact that in the UK, people who have terminal cancer are given a diamorphine. They're given heroin, but of course the brand is completely tainted. So, and of course the brand is no longer in that trademark is no longer in force anywhere. But I don't think any drug company would want to use that word. On the other hand, would you want to use heroin for a completely different product? Well, probably not. But it's not impossible, right? It might be that a drug name where that brand name is no longer used for whatever reason, could that be used for a completely different product where the consumer would make no association between that branded product and the original product that it was first given a name to. Well, this is a question you'd have to really ask companies. Is this what they would want to do? I suspect they probably wouldn't want to, because they would rather come up with their own brand name. So I'm not sure there'd be any. So I'm not sure this problem would actually arise but it could, in theory, yes. In which case, if the trademark is no longer in force and the public has no psychological, it makes no psychological connection between the name and the original name for what it was originally applied for, then I guess in theory you could get trademark on that if you thought that would be a good idea. Okay. Any other questions?
Yes, Vijay, I suppose you have a question.
Yes, sir. Good afternoon, sir. My name is Brijan.
Hello.
And
Hi.
my question is, am I audible?
Yes, you are audible.
Sorry.
So my question is, like, recently, India and South Africa wanted the WTO to temporarily suspend intellectual property rights so that COVID-19 vaccines and other new technologies are accessible for poor countries. But countries like US, UK, and Europe outrightly rejected the same. So my question is, in light of the current situation, how far is it justiciable for intellectual protection regimes to outweigh public health interests?
Thanks for your question. Well, you're asking the right person this question, because I've been involved in a campaign to support the governments of South Africa and India, because I actually think I think we need to get vaccines out to the whole world. And anything that we can do to promote manufacturing around the world is something we should not allow IP rights to obstruct. So I'm very much in support. I did talk to a guy at Fiocruz in Brazil. Fiocruz is manufacturing the AstraZeneca vaccine. And he was saying, well, yeah, we have a license for AstraZeneca, but that does, of course, control our production. It controls whether we can export it to other countries or not, which is not ideal, right? But he did say actually making these vaccines is quite complicated, because you do require you require sourcing of different ingredients. So it is in a way a sort of complex technology in the way that's been said before. But I think, I agree, we should not let IP rights get in the way. Private rights, basically, these are they're not natural rights. They are rights that governments allow to companies because we think it may be good policy to provide certain market incentives to do certain things. But if we give these rights, we have the freedom to take them away, or to reduce the scope of the exclusivity. So I'm very much in favour of access, and particularly this time when every day counts, every day more infections. So it is an emergency situation. So I'm very actually disappointed by my own government. Yeah. Sorry. Oh, sorry. Yeah. So I'm saying I'm disappointed by my own government. I think we should be more supportive. That's my view.
Thank you, sir.
Sir, I have a question.
Yes. Hello. Yeah.
I think he got muted, sir. He will just unmute some. Yes, Rakshit, you can unmute yourself.
Okay, this is Dr. Rakshit Akrwala from India, sir.
Hello.
Hello, am I audible, sir?
Yes, you are.
Yes.
Yep.
Okay.
I can hear you.
So the question is, many a time, just like a COVID pandemic situation, some of the drugs which are newly invented, which are, because of the patent, it has not been sold to and reached to people. Just like, we have international laws for human rights, like, equality of life and all those. So on the basis of the same, is there any law which cannot patent some of the drugs which is life-saving and essential for the humanity?
Well, the answer to that is no, right? Because
any forum we can conclude that these drugs cannot be kept under patency, or you cannot patent when such situation arises, any forum or any kind of law which is internationally prevalent?
Well, there isn't, and I think maybe there should be. What I think it's very important that in 1995 the World Trade Organization, opened up, and the TRIPS agreement requires that patents be available for all fields of technology. And the reason why that language was chosen was that the pharmaceutical industry, in particular the United States, but also in Europe, wanted countries to be forced to provide the patents for medicines without discrimination. And that without discrimination, came into, you can do it different ways, but so whether it's life-saving or not, it doesn't really make it's not allowed to, you're not allowed to make a difference there. On the other hand, there is compulsory licensing, which is certainly possible. So the problem with TRIPS is that it takes these decisions out of the hands of governments. It means they're not allowed, right, to do something about this, which is very unusual, because when you look at patent history, you'll find that most European countries did not allow drugs at all to be patentable until the last 40 or 50 years. Before that, most countries did not allow medicine to be patentable in Europe. Switzerland 1978, Germany 1968, and now we say the whole world has to provide patents for these things, and it is a problem. Yeah, I know that Brazil has a system where patent applications on medicines are assessed by the Ministry of Health, and the Ministry of Health may make a policy decision. But whether it benefits the public to grant this patent. So in Brazil does have a system which might be worth looking at. But elsewhere, not much. Of course, India has a provision in the law, Article 3B of the Indian 3B, I think, of the Indian Patent Act, which does prevent the sort of behaviour that I mentioned about AstraZeneca with its medicine. That probably wouldn't be possible to get a patent on that in India. So India is doing a few things right, but its hands are tied by the TRIPS agreement. So yeah, any last questions?
Yeah, we'll just take a last question, sir, by Shivaram again. Yes, Shivaram.
Sir, your views on right to have prior user or right to have a prior registration, or whether both should be there for infringement and passing of cases. What would be your view, sir?
So you're asking about trademarks, or
yes, sir.
Or
yes,
what?
I'm asking for trademark. Whether prior user is the only requirement, or whether prior user and a mandatory registration is required, or whether both should be there in case of admissibility of infringement. Because under different laws, in the US, it is always the prior user, and that to the first person who is commercially using it. Therefore,
look. Okay, look. I think the answer to the question may not be quite the answer you want, but I think you have to look at how different jurisdictions deal with trademark law. These kinds of things are not necessarily harmonized internationally. So what may be true for the United States may not be true for other jurisdictions. All right. So yeah, it's a difficult one. But I mean, we can have a long conversation about trademark law, but I'm not sure if we really have time. So I would say you have to look at different jurisdictions and how they deal with this particular question. All right.
Yeah. Any other question from sir, or we'll just end up the session? Okay, I suppose there are no questions, sir. So thank you, sir, for informative session. Thank you, sir, for accepting our invitation at such a short notice and delivering a lecture on a very relevant topic.
Thanks for inviting me. Thank you. Yeah, thanks for inviting me. It's been a pleasure. All right.
Thank you, sir.
Okay.
Now I would express the vote of thanks by on behalf of Anand College of Legal Studies. I would like to express my deepest appreciation to today's speaker, Professor Dr. Graham Dutfield, for accepting our invitation and gracing the event with your kind presence.
Thank you.
Thank you for mentioning the importance and of the functioning of the pharmaceutical industry. I am very much thankful to Advocate Hemant Bhai Patel, President of Sri Ramakrishna Seva Mandal, who has been a dynamic leader for showing us the path in law and has always encouraged us to organize such events. I would also like to thank Srimati Josnaben K. Patel, Honorary Secretary of Sri Ramakrishna Seva Mandal. Ma'am has always encouraged us and has been our torch bearer. I would also like to thank Mr. M.B. Prajapati, Director Anand Law College, for his inspiring mentorship. I would like to thank Dr. Rekha Kumari Singh, in charge Dean Faculty of Law, Sardar Patel University, and in charge Principal, Anand College of Legal Studies, for supporting us throughout the event. Finally, I would like to appreciate the technician for broadcasting the event on social media platforms. And finally, I would like to thank all the participants and attendants for their active participation and patient listening. Thank you, sir. Thank you once again. Now, I would request today's speaker, Professor Dr. Graham Dutfield, to kindly lead the session. Thank you, sir.
Okay, thank you very much. Okay, goodbye, everybody. Bye.
Thank you. Thank you, everybody.
Very welcome. Thank you. It's a pleasure.
Thank you, sir.
Thank you, sir.
Now, I would request all the participants to kindly leave the session.
Thank you very much, sir.
Yes, thank you.